All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Marilyn Hyde. Now, please be seated.
Good morning. How's everyone doing on this lovely, rainy Monday morning? No, it could be 95 degrees and 90% humidity. So I'll take it. So good morning again. So this is July 18th. Welcome to the First District Court of Appeals. We have 3 cases set on the docket, only one set for argument. So the first case that we have that's submitted on the brief is C220008, State of Ohio versus Smith. The second case we have is C210534604, State of Ohio versus Champion. And the case we have set for argument is case number C210605, Hamilton v. Barth. If attorneys can please identify themselves and their readiness to proceed.
James Niebering on behalf of plaintiff appellant Mr. Hamilton. We are ready to proceed.
Good morning.
Donald J. Martin Jr. on behalf of the defendant appellees, the Barths, and I'm ready to proceed.
Okay. Whenever you're ready.
Your Honors, if I may reserve 3 minutes at the end for rebuttal. Briefly, we're here in an action which was initiated by Mr. Hamilton to enforce a land installment contract that he executed with the Barths for the purchase of some property down in Whitewater Township. The complaint was for specific performance, and it is based on a written document prepared by an attorney on the death of Mr. Hamilton that was in fact signed by the Barths by their own admission. The document was signed. The challenge primarily is to the sufficiency under 5313, which is the statute of conveyance for a land installment contract. The Barths have alleged that there are insufficiencies and non-compliance with the statute. Most notably, the document was not notarized, not disputed, nor was it.
Well, and I mean, I'm looking at the contract right now, and there was a space for notarization that clearly wasn't completed. So it seemed like that was an acknowledgement, by your client's lawyer that it did need to be notarized, and it wasn't notarized.
There is no dispute that it was not notarized. Right. And I didn't prepare the document, but, as you've noted, there is a space on there for an acknowledgement. And the statute requires acknowledgement, right, not disputed.
So then, so because the statute requires it, and because it wasn't done, how do you get around that? Well,
my position is, number one, there is substantial compliance with the statutory requirements for the land installment contract. It identifies the parties. My position, our argument is it sufficiently identifies the property to be conveyed, which is disputed, the consideration to be paid, the installments, the due dates, the balance due date, and the other requirements set forth in the land installment contract statute.
So you're basically saying that the shall language of the statute doesn't apply?
I'm sorry.
So you're basically saying that the shall language of the statute does not comply, does not apply?
No, it does apply, but my position is substantial compliance with the statutory requirements takes it out of the strict operation of the statute, and it is enforceable as a land installment contract is between the parties, even though it is not sufficient to affect a conveyance under 5313. It is effectively a contract between the parties as a defectively executed instrument, and I believe it's also enforceable as between the parties just as a contract to purchase real estate under 1335 statute.
So are you relying then on the case law when you're saying that it's enough to be enforceable amongst the parties?
I'm arguing that it is enforceable as between the parties.
Right. What are you relying on that? The statute makes it very clear. It has the shall language as to what is required for the land contract. There's no issue here that it doesn't meet all of the shall requirements, right?
It was not acknowledged and it was not
Correct. Okay. So you're now arguing substantial compliance, which is different than what the statute articulates.
Correct.
Okay?
So we have the case of, I want to make sure to get the citations right. Basil V. Vincello, which provides that despite strict statutory compliance, a defectively executed instrument of conveyance is valid as between the parties.
Okay. So it talks about it defectively executed. Was this contract executed?
Yes, it was signed by Mr. Hamilton as the purchaser, and it was signed by the Bars.
But
as
was
the
it
seller.
executed? Because I'm looking at even the language of the contract that talks about recording it after all parties have completed execution.
Yes,
So has execution been completed?
I believe execution was completed.
And
when
how
the
was
parties-
execution completed?
When the parties put their signatures on the document, at which point the.
Then what was the purpose of the statute? If it all requires is for parties to sign and that's a completed execution, then I don't know then why we need the statute.
Well, in order to effect a conveyance of property, it needed to be acknowledged and recorded. Again, we do not dispute that it does not comply with the statute, but given the substantial compliance with the other elements of the land installment contract statute, 5313, our argument is we have presented evidence that it is enforceable as between the parties as a sale, contract for the sale of the property.
I looked at the cases that you've cited, and I've looked at other cases as well. One thing that I noticed is in all of those cases, after the faulty contract was signed or whatever occurred with the faulty contract, the parties went on to perform under the contract. And it was after the parties had performed, had taken on the roles and responsibilities of the contract, that the contract was then challenged. Okay?
Yes.
Can you point to a case in which the parties did not take on the roles of the contract, did not take on performance, and yet substantial compliance was sufficient?
Well, I would argue that in fact, Mr. Hamilton did undertake performance. Again, the contract was executed, I believe, May the 8th, 2018. He tendered the first installment.
But those are elements, those aren't performance. Like for example, the, consideration, the $500, that's an element, that's not performance.
That was all that would have been required of him at that point. The contract specifically provided for payment of the agreed purchase price in installments of $500 beginning on a date certain. And in fact, he tendered, and in fact, the Bars received the first installment under the terms of the contract.
Did they reject the payment?
No,
Or did they put it in a bank account, or did they send it back?
Mr. Barth gave a written receipt for the $500, and subsequently, I'm not exactly sure of the date, they repudiated the contract and returned the first installment. On the due date of the second installment, Mr. Hamilton again tendered a payment, which was returned by the Barth attorney, Mr. Meyer. And it's my position.
Well, so I think getting back to what Judge Gladys was saying, in the cases where there's substantial, where there is confirmation by performance, it's usually both parties operating as if the agreement is effective, and they're taking steps in furtherance of the contract, even though the contract may be defective. And so in this case, I mean, your client tendering the payment was his effort to perform, but then where's the counterparty's performance? Does that make sense?
Their obligations, I think, were established by the terms of the contract when they put their signatures on it. I think they are bound at that point, and the next steps required of either party would be the tender of payments. And nothing further, well, other than recording, which is a seller's obligation under the terms of the statute, acknowledgement and recording, that is all that the contract contemplated as performance.
But did they
Well,
give him access to the property at that point? Like, did they, like, was he able to go onto the property and do whatever he was going to do on the property?
That I do not know.
Okay.
That I do not know. So as we stand here today, the performance was the tender of payments. And my argument is that is all that was required.
I mean, here it says Vendy shall be given possession of the real estate on the date of execution of this land contract. And again, I think all of this seems to be governed by execution. Was it executed? You know, because clearly there wasn't possession of the real estate on the date of execution. Clearly there wasn't the, the recording within the 20 days, which is also provided in the contract upon, having completed the execution. And so even the question of what was the date of execution is quite fascinating because there is no date on the contract. There is no date of notarization and no date of that the contract is entered into.
I believe that there is a handwritten date at the very top of the instrument that says May the 8th of 2018 acknowledges receipt of the payment.
It says down payment $500 paid 5/5/18, check number 1160. But right below that, it says this agreement is entered into on this blank day of May of 2018. So there is no day in which the agreement was entered into. There is a date recorded for a $500 check.
Which I believe is established by Mr. Hamilton's affidavit and confirmed by Ms. Barth's affidavit that in fact a $500 payment was tendered at the time of execution and the receipt was prepared and delivered by Lewis Barth.
I doubt that they said at the time of execution.
The date they signed.
But again, this agreement is entered into the blank day, and then there's no date of notarization. So in addition to there not being a notary, I think, I don't know what the date of execution is. I don't know what the date of entry that everyone has accepted as the date of the contract.
Again, I would argue that that is the date which is supplied by the handwritten receipt across the top of the instrument, as well as the separate receipt of the same date that Mr. Lewis Barth prepared and delivered to Mr. Hamilton at the time.
Is there a case that you can help us with that would support that? Because the note is there. It's very clear, right? That a note like this would operate as the date of the contract, would substitute for the date of the contract.
I do not have a case specifically on that point. But again, my position is as to the statute of conveyance, the 5313, which governs the land installment contract, we have substantial compliance with the mandatory terms. So let's, for the sake of our argument, say there is no date of execution and it can't be supplied by the receipt. We have the names of the parties, the addresses of the parties, the property described by a mailing address, the property described by a parcel number. We have incorporation of the current deed. We have a survey plat, which describes the acreage to be conveyed. We have the consideration, we have the terms, we have the installment amounts and the installment due dates, as well as provisions that relate to taxes and insurance.
Do any of the cases that you cite for substantial compliance have a situation where the contract was not notarized?
None as relate to land installment contracts. There are cases as relate to the execution of lease.
Okay.
One of which is actually a Hamilton County case, which I believe is 9900 Timbers.
Okay.
It's kind of a different case relying on Delfino, which is a different matter altogether, which I'm more than happy to address. I'm anticipating addressing that in rebuttal.
Okay. Yeah, because I think I'll give you 30 seconds, but
Okay.
yeah, if you want to.
I have 30 seconds left.
Time flies.
Yeah, it does. Your time is
I would-
actually up, but I'm giving you
I would
time
also
to wrap
argue
up.
that Section 1335, Statute of Frauds, governs documents, contracts for the sale of real estate, which must be in writing. It sets forth the minimum requirements. I believe the document that these parties executed, notwithstanding the failure to put a date of execution, notwithstanding the failure of a notary, acknowledgement, or recording, satisfies the statute of frauds that is enforceable as a contract to purchase real estate under 1335. They were pled in the alternative in the contract. This is a complaint seeking specific performance of a contract, either substantial compliance under 5313, statute of conveyance by operation of Delfino in 9900 Timbers, or in the alternative, an enforceable contract for the purchase of real estate under 1335.
Thank you.
Thanks, Your Honor. As the court's already recognized two of the defects in the contract, failure to notarize it, the date, but there's two other defects. One is no interest rate. Now, there's something in there that says 0 interest, but that's not an interest rate. The other problem is...
Is there a requirement that there be an interest rate?
Yes, there is. It's in the statute. Case law says that, and there's a case I'm going to point out to you that says that there is to be an interest rate. I mean, this is a contract that's supposed to be paid over a period of 7 years, and the fact that there's no interest on it.
Well, yeah, I mean, that sounds suspicious in many respects, but what if I, like, have a good friend that I want to sell some property to, and I say, you know what, I'm going to give you a deal, I'm going to not charge you interest on this land, you know, is there a problem with that?
Well, I think so. I think, the IRS requires interest. And if you don't have interest in there, they're going to charge you. You know, I've run into situations where that's happened, and people were just kind of stunned to find out that the IRS is going to charge you interest, even though there is none stated in the contract. So, you know, I mean, if somebody comes to me and suggests that, I'm going to give them that advice, because otherwise later on down the pike, they're going to be kind of stunned when they have to pay to the IRS. Now, the other problem with this land contract is, you know, the statute makes it clear that there has to be a meets and bounds description. Now, what we have here is basically two parcels, 63.579 and the second parcel, 3.385. Now, they have the auditor's parcel in there, but the case law is very clear that an auditor's parcel is not a meets and bounds description. And the statute's very clear that there has to be a meets and bounds description. Now,
But, you know, going back to substantial compliance, I believe there's case law out there that allows for there to be sufficient description of the property, and that's been accepted. But again, these are cases in which there was performance.
Yeah, there was no performance here. I mean, what he's attached is some documents. One was an old deed which conveyed 38.74, 79.84, and 11.61, which is much more than the 67 acres here. So that's not a valid deed. Then he has something showing a plat map for 5.3228 acres, which obviously isn't applicable here. And then he's got some kind of a drawing that is not applicable here. So he's attached three things. But there is no meets and bounds description in that contract for the property described here. And without that, the deed can't be recorded because the engineer has to check the meets and bounds description, and there isn't one. A meets and bounds description is mandatory under the statute. So it's non-conforming in many respects. And to address your question of substantial compliance, you know, as the facts show here, Mr. Hamilton had this contract prepared by an attorney for him. Bars didn't have anything to do with it. He brings this contract, and they have it. It's sitting on a table, Mother's Day, their son sees it and says, "What are you doing this for?" And then they are clearly recognizing the inequity of it. Mrs. Barth calls Mr. Hamilton. He comes, picks up his check. They return the check. He picks it up.
So they never cashed it?
No, it was never cashed. They returned the check, and deal's done. It's over as far as our client's concerned. And then through his attorney, Mr. Hamilton sends another check for $500 about a month later, and we rejected. I send the check back and say, this is an enforceable contract. We're not going to accept this. So
So when he came to pick up the check, the return of the initial deposit, do we have information in the record that he basically agreed, okay, yeah, this contract's over?
It would be our position that by coming to get the check and accepting it, that's concurrence. You know, his actions show a concurrence with the BARF's rejection of the contract. So
And then a month later, he changed his mind and sent
a month
more
later,
money.
I guess he had some thoughts about it and saw counsel, and they sent another check, and we reject. So there's been no change in position in the parties. They never occupied the premises. So there is no situation where we can argue there was any kind of change in the positions of the parties. And I would point to the court, as I mentioned in my brief, the case of Schrock versus Spagnardi, which is a 2015 case out of the 5th District Court of Appeals that held that a land contract didn't exist when 53-1302 was not satisfied. In that case, there is no legal description, as here. The amount and due date of each installment payment was not there. The interest rate on the unpaid balance and the method computing that rate was not there, as is here. And there's no evidence that the parties recorded the document. That wasn't done here either. And again,
So on the substantial compliance, and I realize these are not the facts of this case, but assume that notwithstanding those problems in this contract, the parties continued as if the contract were enforceable, and the appellant, moved on to the land, and for like a year was living there or doing whatever he's doing there. At that point, how do we know when there has been enough kind of action consistent with the contract to trigger substantial performance?
well, Your Honor, if you look at the facts and the cases that were cited here, there is an ongoing pattern, 6 months, several years, checks written that indicate it's for purchase of the property. There's an ongoing conduct of the parties that show that there's an understanding of this agreement and they want to comply with it. And then something happens and then we have an eviction or a suit filed. That's not the case here. There's none of those facts that are applicable here. It's very clear the BARFs rejected the contract. Mr. Hamilton accepted the money, sends a check, they send it back, and they move on. So there isn't any facts here which could in any way indicate that there's substantial compliance. This contract was defective, it's not enforceable. The Supreme Court has said that in Davies versus the 1965 case, and then the 2020 case decided by this court following that says the same thing, where there's defective execution pursuant to the statute, which says it shall, as you pointed out, Your Honor, it shall be executed in compliance with the statute. The instrument is defective. The Supreme Court made it clear that if you don't follow this, that statute is meaningless. And so that's the case here. I think the court has to follow the statute and rule that this contract is not valid and unenforceable.
Can you address the alternative argument, which is that even if this contract does not comply with the statutory requirements of a land contract, that it is still an enforceable contract? An enforceable contract to convey land, not under a land contract?
Your Honor, I don't see how it could be. Clearly, if you look at the bare facts here.
No, but the heart of that argument is that that it complies with the statute of fraud, and that it could be then, in a way, converted from a land contract to just a contract.
Well, I think if you're looking at some kind of an equitable argument, I think you have to look at equity here. There is no equity here. This is an unjust situation. You have this gentleman coming to two elderly people, 71 and 77, and as the court knows from the record, Mr. Barth was declared incompetent by the probate court just a month or two later. So he's coming to two people wanting to buy close to 67 acres which is appraised by the auditor at about $450,000, and he proposes to pay $55,000, which is less than 12% of the purchase price.
Let me make sure I understand. Are you saying that when a contract fails to comply with statutory requirements, that equity can still be?
Well, I mean, that's an argument they
Right.
make. It's my argument, it's very plain and simple, very plain and simple. If you're going to have a situation like here, where the purchase is going to be in excess of 1 year, it's mandatory that you comply with the land installment contract provisions. If you don't have a contract, even if it's in writing. The statute is clear. You know, you made the choice, as Mr. Hamilton did, to purchase this property with payments in excess of 1 year. That has to comply with the land installment contract. If it doesn't, it's not a valid contract in any respect. If you don't look at it and interpret it that way, that statute doesn't mean anything. It renders it all meaningless. The legislature made it clear. You've got your choice, and Mr. Hamilton, in this particular case, wanted to buy the property over time. And because he made that choice, he has to comply with the land installment contract statute and do what it says. He didn't do that here. We don't have a valid enforceable contract. Can't be done.
Okay, unless there's any other questions, was there anything further?
No, Your Honor, we're just asking you to affirm the trial court's decision of summary judgment on both the complaint and counterclaim. Thank you, Your Honor.
Thank you. I've reserved your 3 minutes.
Thank you. At the outset, plaintiff made two alternative theories of recovery. One being substantial compliance with the statute of conveyance, which is the land installment contract 5313. I believe Mr. Meyer's argument goes to the sufficiency of the instrument to effect a conveyance of real estate. We are arguing that based on substantial compliance with 5313, that instrument is effective and enforceable as against the bars. Make an alternative argument that the parties' May 5th, 2018 agreement more than adequately satisfies the requirements of the statute of frauds 1335, identifies the parties, the property to be sold, and I believe, as the court has noted, the requirement for the sufficiency of a legal description under 1335 is not a meets and bounds description. It is simply a description of property sufficient to distinguish it and clarify what is the subject matter of the contract. I believe that evidence has established that. At least, I believe there's a genuine issue of material fact whether the evidence has established the sufficiency of the legal description. I would bring to the court's attention Basil versus Vincello, 50 Ohio State 3rd, 185. Citizens National Bank versus Dennison, 165 Ohio State, 89. A defectively executed conveyance of an interest of land is valid between the parties in the absence of fraud. The matter of the equity, the fairness of the purchase price was never raised in the motion for summary judgment that was presented to the trial court. As for the doctrine of part performance, I believe that all that is required is that the plaintiff show facts that establish acts and conduct of the defendants, the bars, that would hold to an amount to a representation that they propose to be bound by the terms of the agreement, which I believe they did when they put their names on it. They accepted a $500 installment, and to not avail themselves, the bars, of the statute to escape performance. It is their statutory obligation to record it, and I believe their acts and conduct by execution of the document and acceptance of the installment, which is all the performance that was required at the time.
But your client took it back, right?
I believe that the return check was actually issued on the BARS account, so the check was in fact negotiated. I believe I attached a copy of it, and I didn't bring all the exhibits to my brief.
Does that matter, though? I mean, whether they deposited it into an account and wrote a check back, I mean, the bottom line is that they returned the money to him and he accepted the money.
But they repudiated the contract. So I believe, number one, no further action was required on behalf of Mr. Hamilton. And in fact, he advised them, and all this is in a very compressed period of time. I want to say within 10 days.
And I believe you're right. I believe that it was their own check that was issued as a return.
Within 10 days, they repudiated. He comes and gets his check, and he advises them, I'm ready, willing, and able to proceed. I am not acquiescing into your repudiation of this contract. And again, I think their conduct by mere execution of the document and acceptance of the first installment, I think evidences their intent that we are in fact intending to sell this piece of property. And as far as the Delfino case, which is the underlying authority for the 9900 Timbers case, which came out of this district, the Delfino court specifically says, since the plaintiff did not request specific performance, it's not necessary to decide in this action whether a defectively executed lease can be treated as a contract to make a lease, which can be specifically enforced. Delfino and 9900 Timbers don't even get to this point because of the remedy sought in those cases. I believe we have substantially complied with the statute of conveyance, 5313, to the point that the contract is enforceable as against the bars. I believe it is, at the very least, a genuine issue of material fact, whether the document complies with 1335, statute of frauds for the sale of property. I believe whether or not there's a date, and I believe there's in fact a 0% interest rate, so it's not blank in the parties' land installment contract.
I want to just ask you one question before you leave, okay?
Oh.
And because you're past your 3 minutes, but I really want you to answer this question. For a land contract, what is required for that land contract to be executed? What is your opinion on that?
The parties put their signature on it.
Okay.
And I believe then subsequently there would be an obligation to have a notary complete the acknowledgement and then the instrument be recorded. I think execution is parties put them in.
Is signing. Okay. All right, thank you.
Thank you.
Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a wonderful afternoon.
The Court of Appeals, First Appellate District.